Tēnā koe, Mr. Speaker, kia ora tātou katoa e te whare. Kia ora, Mr. Quinn. Mr. Speaker, tomorrow marks the occasion of 20 years since the Bill of Rights landed on the New Zealand judiciary. And that's important because the Bill of Rights, together with the 1993 Human Rights Act and the nation's founding document, Te Tiriti o Waitangi, provide the framework for a strong and evolving constitutional discussion which the Māori Party will proudly lead over the next few years. Alongside all of that, of course, the Māori Party is also proud to claim responsibility for this nation's signing up to the United Nations Declaration on the Rights of Indigenous Peoples as well, providing Aotearoa with a set of international benchmarks regarding Indigenous people in the law. And so, as we come to this legal services bill, the Māori Party does so looking for the same positive reform that Dame Margaret Baisley noted in her report, highlighting a range of deficiencies within the legal aid system, including the poor quality of legal aid services and serious service delivery issues. Dame Margaret made some far-reaching recommendations, including the following: ensuring aid is available equally across the country, taking into account geographical, social, cultural and economic factors. Extending social services into the courts to reduce the social deprivation of court users and their families and whānau. And creating a better focus on legal needs for Māori and Pacific peoples and the barriers they face. Dame Margaret also made the point that if the legal aid system fails Māori, then the system fails altogether. The stories of delays and deferrals are legendary, and I note here the situation of 19 people caught in the 15th of October police terrorism raids on Tūhoe, whose applications for legal aid weren't even looked at by the Legal Services Agency for 4 months. And all Māori electorate MPs know of people who have made complaints about incompetent and corrupt lawyers, dragging out the legal process to maximise their fees, or recommending their clients plead guilty because they are too lazy to do the necessary groundwork to defend their Māori clients properly. So we welcome the proposal in this bill to have lawyers sit competency tests before going on the legal aid roster. Mind you, I note that comments about bad lawyers at the Manukau Court in particular need to be balanced alongside the reality of the huge workload and woefully inadequate resources provided for the high numbers of defendants appearing before that court. And I quote from an email we received just after the Baisley report was released, which said, "There is no doubt that the Manukau Court is known as one of the most difficult courts in the land to work in. This does not mean, however, that it attracts the worst kind of lawyer, quite the reverse. One has to be very dedicated to work in this court. Many of our finest lawyers have worked and continue to work in this court. Corina Williams and Eddie Paul, to name just two. I was appalled to find that some of Ms. Baisley's findings were based on anecdotal evidence. In common terms, this just means gossip. There is so much work in the Manukau Court that I can't see why any lawyer would even need to be gaming the system, as she puts it. The majority of hard-working lawyers in the Manukau Court don't need this kind of publicity." Mr. Speaker, the Māori Party also supports the right of all people to have access to justice, as proposed in this bill. Indeed, the denial of that access to justice was one of the main reasons behind Te Hikoi Taku Taimoana, the birth of the Māori Party and the drive to repeal the 2004 Foreshore Seabed Act. One major point of concern I do have, though, Mr. Speaker, comes from a meeting last year where Māori tribal and legal leaders expressed their concern to the Minister of Justice about the number of lawyers appearing before the Waitangi Tribunal and the consequential loss of tribal control to lawyers acting on their behalf. It's proposed that the Legal Services Agency and the Waitangi Tribunal develop options that retain the benefit of legal aid but place controls on the number of lawyers, the cost of lawyers, and the domination of lawyers over Māori issues. I note, however, that much of that will be blocked by this bill denying legal aid to those negotiating settlements with the Crown, which in our view simply adds another problem rather than dealing with the original one. We do not support proposals to deny legal aid to those negotiating treaty settlements. Mr. Speaker, my gut feeling is to not support this bill because although it addresses general issues which impact on Māori, it does little to address the specific needs of Māori. And given the numbers of Māori appearing before the courts, I note that there's nothing in this bill to support the reopening of the Māori legal service either. However, the Māori Party will support this bill to first reading to allow time for groups and individuals who have a stake in this matter, including Māori legal practitioners, Māori involved in the legal aid process, people who have worked for the Māori legal service in the past, Māori who have been ripped off by legal aid koretakes in the past, Māori involved in treaty settlements, Māori social service providers and others, to tell the Select Committee what they think of this bill and how they think it might be changed to improve services to Māori in the future. Our vote beyond first reading will be determined by what we hear through the Select Committee process. Kia ora tātou katoa.